Good morning. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with Labor Attorney Jung Bo-soo, we will explain the legal terminology, which is the period of exclusion. It's not easily mentioned, but we need to know exactly about this term because there are many cases that apply to this. So could you explain about this terminology first, please?
Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Regarding the period of exclusion, that is like when employee was fired or transferred undesired place, then employee may take legal action for remedy to the Labor Commission. Then Article 28 of the Labor Standards Act stipulated employee should take legal action within 3 months from dismissed or illegally or unfairly treated period. So without taking legal action within this period, the employee cannot have any protection by this Labor Commission. So that's why it is called the period of exclusion. So the reason why they stipulate this the limited period is to secure the legal liability or some trust of their legal action. So when we deal with this one, so we do not know about labor law, then we usually get disadvantageous treatment. So to avoid such a disadvantageous result, we have to be familiar with what is legal right. Yeah. So regarding this case, I had 2 different experiences regarding relate to this the period of exclusion. So especially this morning, I received a phone call from one professional foreigner who has been working in Korea. So exactly 2 months ago, he visited this labor law firm and asked for some remedy claim. So I explained sincerely how he can get some protection. So I warned he should take it within 3 months. So he said yes, he wants to take legal action. So he'll come back and take legal action within 3 months. So I forget about his visiting here. Then when I returned to the Lunar New Year's holidays, I confirmed some special message. So he wanted to contact me. So then I called him. He told me the deadline was the January 29th because he was fired October 28th. So it's been already 3 months, but during the Lunar New Year's holidays, he could not contact me. So he was very sorry that he missed this 3 months, the exclusion of the period of exclusion regarding his legal action. So, but he accepted it because he forget to follow this requirement. So this is the first case. The second case is related to the some Korean branch manager. Once he worked for one of the very famous company. The company is to produce the notebook, the computer. So this company was very famous. So this Korean branch manager had not had a good performance. So the head office assigned him to work in only sales position, like in charge of sales department. Actually, he used to in charge of the all Korean operation, but they demoted him and assigned him only working as a head of sales team. So he complained. So he warned the company he would take legal action. The disadvantageous assignment. So HR manager asked this labor authority about how to handle this case. Then when I received this email request, I think the company's the order for his job transfer was made in the August. So it's been already 5 months. So I told them that there is a period of exclusion. So the Korean branch manager has neglected to take legal action within 3 months. So now he cannot take legal action. So company didn't respond to his complaint because it's been already passed. So I think this relates the period of exclusion according to Article 28 of the Labor Standard Act. So some wrongful dismissal or some demotion or wage reduction, if they filter it as a kind of unfair, then they should take legal action within 3 months. But this Korean branch manager didn't know about this legal requirement.
I see. So thank you for introducing two actual cases. But in case of the second case, it's too long period that he missed the period of exclusion. But the first case, because it's not within the the 3 month period is not working day period. He also just passed the period of exclusion, which is a pity from taking a legal action. So this is a part of ignorance of the Korean labor law. So I think those people who have experienced similar situation like unfair dismissal, they should consult to our labor law firm and yourself. And although you have already told them, they missed the period, which is a pity. Do you agree?
Very sorry to hear. I think I'm very fully, I agree with you. They should be familiar with the Korean labor law. So even though they don't use it, but to not to be taken advantage, not to have some disadvantageous treatment, they must be familiar with this kind of legal requirement. So even labor union regarding unfair labor practice, company assigned key union members to the very distant place without some following the collective agreement. So they thought it is unfair labor practice, but company didn't follow the 3 months legal requirement. But it's been already more than 4 months. Then even though they felt it unfair, but they could not take legal action because it belonged to a period of exclusion according to Article 28 of the Labor Standard Act.
In this occasion, we need to differentiate the two terminology, which is in Korean 각하 and 기각. It's all translated into like dismissal, but can you explain the two difference of the two terminology?
So 기각, 각하 is basically the same. The Labor Commission rejected the employee's claim. So here 기각 is 각하 means something. The eligibility for legal claim is not sufficient. So the Labor Commission rejected their claim before they reviewed the case. So that is what we call rejection of the case or 각하. But 기각 or the termination of the case is so they satisfy the legal requirement in this remedy claim, but the severity of punishment or I think some company followed strictly about some severity of punishment or region of punishment, also disciplinary process. So Labor Commission rejected or dismiss the case even though they carefully review the case. So it is basically different. Like Kaka is rejecting before they review the case, but the Gigak is after they reviewing the case carefully, then judge it doesn't belong to the unfair dismissals, and company dismissed the cases, so we call it Gigak. Yeah.
I see. So in order not to miss the period of exclusion, I think it's important that those who are experienced the unfair dismissal, they should come to like expert like Gangnam Labor Law Firm to receive the appropriate advice, so that they can retrieve their own right.
Yeah, that's correct. Yeah, fully I agree with you. Thank you for your explaining that. Yeah, so yeah, they must be professional in their job or in their field, but labor law is very professional. Without being familiar with this kind of law, many normal people do not know how to take legal action, how to be protected, how to respect the required period, like period of exclusion. They are all important. So that's why they need the professional legal service from some labor attorneys like this Gangnam Labor Law Firm. Yeah.
I see. Thank you very much.
Okay, thank you for watching. Okay, bye bye.